cite for me for the proposition that there's a federal constitutional right to vote?
Yes, Your Honor. FEC versus Akins, the Burdick case, Reynolds, Saylor, Gray, Baker, Classic, all U.S. Supreme Court cases, and all in different ways talk about the fact that you have a right to vote and to have your vote counted, to have your vote not diluted, not limited, not diminished by fictitious or fraudulent votes. In fact, Reynolds says that as well as—
Reynolds says as an equal protection matter, everybody's vote ought to be counted the same. So I'm trying to figure out whether you're making an equal protection claim here or whether you're making a due process claim. Because those are the only two parts of the 14th Amendment that
Yes.
would seem relevant. I don't think you're making an equal protection claim because you're not claiming that your clients are in a class of people that are being treated worse than other people. So are you making a due process claim?
Well, the complaint does assert both.
But tell me what your due process claim is.
But certainly our due process claim is based upon the fundamental right to vote as recognized by the Supreme Court in the cases that I listed, including the Reynolds case, but also in Gray in particular.
Could Arizona choose not to elect its Secretary of State, but rather have that person appointed by the governor, if its constitution so provided?
Yes, I believe that they could.
So there is no fundamental right to vote for Secretary of State, is there?
There's only a fundamental right to vote for Secretary of State if
the state grants the right to vote.
If the state is electing a certain position. It could, a state could do away with the Secretary of State if its constitution allowed, and then there would be no vote at all.
But a state can also have positions for which there's no voting.
That's true. But in addition to that, if they do have a vote, they have the right to establish time, manner, place of the vote. However, there are guardrails to that. They cannot violate the federal constitution.
What I'm trying to figure out, and I don't want to joust with you about it, is how you think what provision of the federal constitution you think was violated by use of electronic tabulation machines, and what case you have that supports the notion that using electronic tabulation violates the federal constitution.
Again, in Gray in particular, it talks about the fact that diluted votes, diminished votes—
Well, but the problem with diluted votes is that's a vote that's actually cast that is somehow not counted as much as somebody else's vote.
And in this case,
just focusing on these two plaintiffs, who I assume now are only really asserting standing as voters as opposed to candidates, because the election's over. But as the voters, what evidence is there that their votes won't be counted in the same manner as everybody else's?
well, the unreliable nature of what can occur when a malevolent actor intrudes into an election system and how the votes are being counted is what our complaint is all about.
The complaint is about the potential for bad actors to influence the system.
Not just influence the system, but to switch votes, to dilute votes, to add votes, to diminish votes in an undetected way. And we had numerous experts, credentialed experts, that looked at this prior to our filing of this lawsuit, and we made sure that we had a plausible argument to be made to protect the democracy, the democratic nature of the vote. I wanted to go to the other point you just raised about the fact that the plaintiffs in the case are now only voters and not candidates. In fact, we would say that's not the case.
Well, they lost the election, did they not?
Well, the election is over, and one very important point is
there's another election's coming up, but we don't know whether they'll be fortunate or unfortunate enough to be candidates in the next election.
Yes, but in the complaint, as it was alleged, this was for prospective injunctive relief. not just on this single election of 2022. That election is over.
I'm not questioning for a moment their standing as voters to seek that relief. I'm just saying the complaint that they raised was that we're also seeking this relief because we're going to be affected by this next election, and that seems to me to be moot as candidates.
I don't think it is moot, Your Honor. Standing is determined by the facts that exist at the time of the complaint.
The Supreme Court said that you have to have standing throughout the entirety of the proceedings. That one might have standing at the time a complaint is given, but you might lose the standing because of the way events occur later. I'm not sure you want to spend a bunch of time on it because I'm not questioning the voter aspect of it at the moment.
No, I don't, but I think the difference between candidates and how they are impacted by this system and voters is a real difference. And these are candidates who at the time that the complaint was filed had standing. An error in our judgment was made in dismissing the case, and they should not lose through mootness their right to proceed in light of the fact that there are going to be future elections.
So are you claiming they're capable of repetition exception to mootness?
Yes, I don't understand. It's capable of repetition. In addition, the Ninth Circuit has looked at and evaluated in Center for Biological Diversity case.
But being a candidate is not something that's capable. I mean, it's not something that happens very frequently, and at least my experience, it seems like it's moot as to them as candidates.
Well, and future elections are not moot. The defense has not raised mootness as an issue, and they have a high burden. The only time that mootness would kick out a case that had standing when it started is if there is absolutely no relief that can be granted to the plaintiffs at all.
On that point, can I ask you a question? Do you have the right defendants at this point?
Yes, I believe we do. Mr. Fontes has replaced.
Can Mr. Fontes change the election machinery used by the? I take it you're only challenging the Maricopa County use of electronic tabulation.
And Pima County, Your Honor, yes.
Only those two counties. So
yes. In
the rest of the state, you think electronic tabulation works fine?
Well, we were focused on these two states.
Well, but if it's a violation of the Constitution, we should forbid it in all parts of the state, shouldn't we?
Yes, and we do not disagree with that. But they are not all defendants.
As to Maricopa County, Mr. Fontes is no longer the recorder.
Yes, he's Secretary of State.
That's right. And former Secretary of State Hobbs is now governor. So I'm asking whether or not, and maybe this is an easy thing to fix, you really mean this suit to be against Mr. Richer and Mr. Fontes?
Well, it's against the county board of Maricopa and Pima County and Mr. Fontes at this point.
Okay, so you're not bringing a suit against the current county recorder in Maricopa County?
I don't believe so, Your Honor.
Okay.
Counsel, I have a question.
Judge Gould.
When Judge Hurwitz is done, I have a question.
You go, please.
My question is this. Does the record contain any evidence that vote counts made by human processes, like human counts, would be more reliable than vote counts made by the electronic voting machines?
Yes, Your Honor. I believe most all of the complaint asserts that fact and requests.
I was asking not what the complaint alleged, but whether there was any evidence of that wasn't submitted in this record.
Well, I would submit that under Rule 12, it is only the complaint that should be considered. And at least in my experience, when a complaint is filed, other evidence that comes in, except in the unusual circumstance, is not considered on a Rule 12 motion. And so all of this other evidence, which basically turned on its head the Rule 12 rule that facts in the complaint are accepted as true. And what happened here is the facts in the complaint were viewed as false and rejected resoundingly and consistently, which is reversible error. It is critical to this case that viewing the complaint, which was a detailed complaint with footnotes, and going outside of that.
But let me just stop for a second, because I think you may be mischaracterizing what Judge Tucci did, but I'm not sure. My question requires that you accept my premise. It seems to me the fundamental question posed by this case from your side is whether or not a system which can be manipulated is unconstitutional. And that's why I think Judge Gould's question is sort of pertinent, because we all know that hand voting can be manipulated. The Supreme Court's told us that in Bush versus Gore. We all know that from history. So my question is it enough that the system is capable of hacking or manipulation for you to state a constitutional violation? You haven't alleged that it actually was. You just alleged that it's capable of being manipulated. So let's assume that that allegation is true. Is that sufficient to state a constitutional violation?
Yes, I think that it is.
So if I were to bring a complaint against a county that did hand voting, hand counting, as your clients seek as a remedy, and I had evidence that hand counting had often been manipulated in the past, votes had been thrown in the basket and people had ignored them, then I would be entitled to a declaration that hand counting was unconstitutional?
Your Honor, in this case, on the record, the difference between hand counting, where minimal errors or issues or even fraud can occur, and over hundreds of years, there have been instances where it has occurred, and the experience of the United States has reflected those minor
that's
matters.
The reason we went to. There's the reason that electoral systems went to different measures of counting, because it was widely documented that hand counting was the most inaccurate way of counting.
But what we now know, Your Honor, is that election machines that are electronic can be manipulated in exponential ways.
No, I understand, and I'm taking that as a fact for a moment, because you allege it. My question is the potential for manipulating the machines enough to make the use of them unconstitutional?
Yes, it is.
Tell me, under what case?
Under Susan B. Anthony, substantial risk of harm is sufficient. Under this court,
it's sufficient to give you standing.
yes.
The question is it sufficient to make it unconstitutional?
Yes, and I believe it is under the gray standard of fictitious, and if it is under a hand count, it certainly is under an electronic machine count.
Then what system would be constitutional in your view?
Well, the hand count system is
No, but we know it's subject to enormous fraud and manipulation.
nowhere near.
We know presidents of the United States have been elected because ballots have been thrown out and not counted correctly, or corrupt county recorders have provided incorrect things. So my question is there any system under your view of the law that would be constitutional?
Yes, Your Honor. I think it's laid out in the complaint. We
I know, but
describe it.
This is a legal question. It's not a matter of allegations.
Sure.
If your test were to be applied, which is that the system is capable of manipulation or fraud, then isn't it true that there would be no system that would be constitutional?
Well, it needs to not only be capable, but to cause harm. And if it is harmless error, if it is minuscule error, if it is fraud at a level that doesn't make a difference, then it wouldn't be. But this is not that case.
We know in this case you've gone through and lost a series of state election challenges. So we know that the vote, at least to the ability, to the extent the law allows you to challenge it, the state courts have found that the vote was accurately counted. Correct?
Well, I have not been involved in those cases,
it's not
and
you,
whether they
your clients.
the question is not whether or not there was hacking of the 2022 or 2020 election or any other election. We are not looking back at overturning any
and that's
election.
why I'm asking. You're saying the system is capable of manipulation, right?
Yes.
You're not alleging that it was actually manipulated.
Correct. Well, it could have been. We
Could have
don't
been,
know,
but-
and there are a
but
lot of
but
reasons.
But you don't allege that. I've
We
read
do.
your complaint.
Well, we don't allege that, but we do allege that there are a number of issues that occurred that have serious questions behind them that have not yet been answered.
Weren't those questions that you were entitled to address in the state electoral contest? In other words, you could say, Mr. So-and-so says he voted, but his vote was not counted. You could say, you could do any number of things there. But this case is about the potential for manipulation, is it not?
Well, it is a prospective injunctive relief
Right.
case. We are not looking back. We are only looking back for purposes of historic fact background. That's all. We're looking forward. And so on the legal question that you raise, if it can make a difference, and here we have alleged it definitely can, exponentially, people can get into the system through a number of different manipulations and vulnerabilities that have been testified to by serious experts across the country, and it's being ignored by the courts, and the courts are shutting down review. Why? The courts should allow discovery. This case gets beyond the Rule 12 argument that you shut down the case and close down discovery. This complaint gets beyond that.
Counsel, the biggest hurdle I have is the page 14 of the district court's opinion, where he describes it as a long chain of hypothetical contingencies that must take place for any harm to occur. What's your response to that? I'm not sure if are you familiar when I'm talking about the 4
Absolutely.
points? Yeah, can you respond to that point?
Certainly. Couldn't disagree more. The long list of alleged security failures that we have alleged, the safeguards that fail to detect, the testing and veracity testing that is claimed by the defendants, that we have a whole series of paragraphs in the complaint that dispute. Each of those results in an overall view that this isn't speculative at all. It has happened a number of times across the country, even in Arizona. The voter registration computerized system was hacked, and that is in the complaint. And the paragraphs where congressional committees held committee meetings in 2018, between this 2016 and the 2020 election, letters written by U.S. senators, all in our complaint about the difficulty, the issues.
You're about to run out of time, and I'll give you a couple of minutes for rebuttal because we've used a lot of your time with questions. But I want to be just clear in my own mind. Your case is based on, however likely or unlikely, the potential that the system may be manipulated, correct?
Well, it's based on the unreliability of this system.
I understand. I mean, you keep saying that, but you're not contending that voting machines unreliably tabulate votes. You don't have any contention in other words, if they're perfectly observed and perfectly protected, there's no allegation that they miscount votes.
Well,
they're a much more reliable way of counting votes than by hand. What you're contending is that an outside actor could get into the system and somehow manipulate the voting, correct?
Your Honor, the most hardened computerized systems in the United States, military systems, have been hacked. And I would argue...
You're not answering my question, so I understand your point. I'm trying to figure out whether you're arguing that voting machines unreliably count votes, or whether you're arguing that the vote count can be manipulated by an outside actor hacking it. I think it's the second and not the first.
No,
if it's the first, I see no allegation in your complaint that voting machines unreliably count votes. It's that somebody else can get into it and make them unreliable.
They could unreliably count votes if they're not set up properly, if they are hacked into in order to make them...
Well, you're not going to answer my question. I asked you, so
I
guess I'll stop asking it.
No, I do want to answer your question.
Well, it's a very simple question. I have a machine here. Let's assume it's not It's one of the machines used in Maricopa County. It's not connected to the internet. It's not possible for anybody to hack into it. Are you challenging in this case the accuracy of that machine, that counting the votes that are fed into it?
I can only say that
No,
depending...
I think is the answer, isn't it? And you're not giving away your case. I'm just, there's
I
nothing in your
understand,
case that says that.
But the number of things that can play in, the manufacturer. What if the manufacturer, and many of these machines are made overseas by foreign enemies of ours, what if that manufacturer puts into the system an undetected device that is filled with malware?
Now if you're talking about those what ifs, I'm back to Judge Bumate's question.
But that is in our complaint, paragraphs 90 to 92.
The judge characterized that as speculation. That it may be that Kim Il-jung is manufacturing these machines. I don't think you could allege that, or you don't think anybody could say that in a press conference, because when people say it in press conferences, they get sued.
It has happened.
But that's speculation. The argument that you're making based on allegations is that the system is subject to manipulation.
It is.
I think I thought that was a fair characterization of what you were arguing. Is it not?
It is subject to manipulation. The machines are subject to manipulation as well. And yes, that's
Thank you. I
correct.
took you over, and we'll give you some time for rebuttal.
Thank you, Your Honor. Thank you.
Who's going to up first for the respondents?
Good afternoon, Your Honors. May it please the court. My name is Kara Carlson. I represent Secretary of State Adrian Fontes. If at all possible, it might be beneficial to reserve some time for Maricopa County, specifically if there's any factual questions that you have.
Your side has 20 minutes, and you can use it however you want.
I understand. I'm just trying to table set to make it most effective for the court. I think that opposing counsel really started and ended his argument with the fact that the machines are allegedly open to manipulation and there are potential for bad actors. And that really sums up the issue with this case, is that it is all speculation. They have failed to show.
Well, what if it's not speculation? What if they've plausibly alleged that electronic systems are capable of being hacked by bad actors? Let's assume that's what they've alleged. Does that make that a constitutional violation?
I do not think so, Your Honor, and there's a few reasons for that. First of all, as you pointed out earlier, any form of vote counting is susceptible to some kind of manipulation. We have a long history of recognizing that all different forms are susceptible to that, and we know that the United States Constitution empowers the states to choose the method of administering elections. That is what the state of Arizona has done here. And I don't think that you can consider only the allegations that are made in the complaint that there could be some kind of susceptibility to manipulation without also considering all of the not factual allegations, but legal requirements, the statutes that require the pre and post-election logic and accuracy test to make sure that the paper ballots that humans look at and humans put into the machines run the same way, get the expected result both before the election starts and after the election is over. And that's not a factual allegation, that is a legal requirement. We have the hand count audit, which takes actually voted ballots and looks at what the result is. And does that match up with what the machines have produced? So this, even if you accept the idea that there is this potential for abuse manipulation, just you cannot excise the statutory safeguards, the regulatory safeguards that are put in place, overlaid on top of that, to ensure that those very things don't happen.
Well, that seems to be getting to the merits, though. That seems to suggest that there is standing then to get to the merits.
I don't think so, Your Honor, because it's a 12B1 motion or order to dismiss that's looking
Well,
at.
you're suggesting we should look at the laws and whether or not there is, the likelihood that there is manipulation, not that there's no standing to suggest that there's manipulation.
Well, to be clear, I was trying to answer
I see.
Judge
Okay.
Hurwitz's question.
So why is there no standing? I mean, and it does seem to say that Susan B. Anthony does have a lower threshold. There's a substantial risk that the harm will occur. Why haven't the plaintiffs made that? Seems like a pretty minor or low threshold.
Well, the Susan B. Anthony case is a part of a long line of cases of really regarding First Amendment chill. And in that case, it wasn't a hypothetical. You had a billboard that had very specific language, don't vote for this guy. He supports taxpayer-funded abortion. And you had this Ohio law that said if you make a false statement about a candidate before an election, there's actionable. You can take action against that activity. And Susan B. Anthony's list had that billboard. They took it down, but that was a case where you could easily, that was something like that would happen again. Well, and again, you had very specific facts where there was concrete particularized
Well, there's
injury.
specific facts here. I just don't know. To me, it does seem speculative, but if we're taking the Susan B. Anthony line of substantial risk, they might have made that.
I think that if you look at Amnesty International versus Clapper, I don't think that they can. I think that's more analogous here, because unlike Susan B. Anthony's list, which was individualized plaintiffs with a very set theory of facts, and then a long line of case law going back about First Amendment chill, this was a much more amorphous right.
That case was about pre-enforcement action, essentially. So you're saying that we should cabin Susan B. Anthony to the First Amendment context on chill, and then in this case apply the traditional, Lujan factors, essentially.
Yes, I think so.
Ask you a question that's troubled me a little bit about this case. Normally, the Supreme Court tells us not to assume Article III jurisdiction and then move on to the merits. But in this case, the 11th Amendment analysis requires a determination about whether or not a federal claim has been pleaded, a federal constitutional claim has been pleaded. Because if it hasn't, then there's 11th Amendment immunity. Can we skip the Article III analysis and only do the 11th Amendment analysis?
I think that you could. I don't think that that's...
Normally, the Supreme Court says, don't assume Article III jurisdiction and move on to the merits. But the merits here, really, whether a constitutional violation has been alleged, is a predicate for suit against the state officials under the 11th Amendment. So I'm trying to figure out whether or not we could skip the Article III analysis and move just first to the 11th Amendment.
Right. And to clarify my answer, that was not that you should. I think that if you find no Article III standing, that is the end of the road.
I guess I was asking a different question. What if we thought Article III standing was our close question? This is a hypothetical.
Right.
But that the 11th Amendment analysis was much easier. Could we do the 11th Amendment analysis and skip the Article III analysis?
No, I don't think that you could.
Really? They're both constitutional in nature. The 11th comes second. Judge Gould.
I thought the Supreme Court had a case saying that we could not skip the Article III.
Yeah, it does. And that's why I was asking the question in the context of an 11th Amendment case.
And just in June in U.S. v. Texas, the United States Supreme Court, talked about how you can't just skip over, and it was in a similar, it was in an enforcement case against the executive, but it talked about how Article III standing is not just a speed bump on the way to ruling on the case. You have to.
Okay. So let me ask you the question. The reason I asked it is I want to ask the question the other way around, which I think may be harder. If we find there's no Article III standing, can we skip the 11th Amendment analysis? They're both constitutional analyses in nature. Are we required to address both, or can we rely only on if we find an absence of Article 3 standing on the first?
I believe if you find an absence of Article 3 standing, that you are not required to do the 11th Amendment immunity because there is no claim at that point.
So what would, I want to put you in the position of the plaintiffs for a moment, which is not the job you signed up for. What kind of allegations about the system would be sufficient in your view to state a triable claim?
Well, I think there are two issues. One, you could have a case like curling where there were not only actual concrete allegations of harm and injury in fact. So that's one way, is to have actual evidence, not evidence of a potential, but evidence of.
So let's assume there was. That's why I want to test this. And
Okay.
Let's take it outside the context of this system. Let's use hand ballot voting, in which we know there's been enormous amounts of evidence of fraud and manipulation in the past. If you had evidence that hand ballot voting had been subject to fraud and manipulation in Arizona in the past, could you attack the constitutionality of the hand ballot voting system in advance of an election?
Yes.
You could.
Yes, because I want to make sure that I understand your question. I'm answering your question. Your question is that you have evidence that there's issues with hand.
Yeah,
vote.
obviously this election hasn't taken place yet.
Right.
But in the past,
Right.
county recorders in the distant counties have decided that not to count the votes of the people that they don't like. Could you get a determination that the system was unconstitutional, or could you merely get an injunction to prohibit people from engaging in the illegal conduct?
Well, I mean, that is why you would be in state court versus federal court, right? The federal court injunction would be against that specific conduct, whereas going into state court and litigating maybe the state court claims and whether that state law is constitutional.
Yeah, I guess I was trying to distinguish between a systematic attack on a method of counting and an attack on the particular counting in a case. I understand the second one has to occur in state court because there's a mechanism for contesting the election. Can you make an advance attack on the system systematically because you think it has the potential for being inaccurate?
Not because you think it has the potential.
Well, even if there's some demonstrated evidence in the past that it was inaccurate. Because it seems to me, even though this case is not about hand balloting, that if that's what the law is, then we can't have hand counting.
Well, I think that goes back to one of the earlier questions from this court is whether if any modicum of error rises to the level of a constitutional claim, then how can we have voting at all? Plaintiffs' counsel attempted to answer this question by talking about, well, if it's harmless error, but we have a long, at least recent history in Arizona of having very close elections. You know, the Secretary of State won by over 200 votes. In 2016, there was a congressional district Republican primary that was decided by a couple dozen votes. So in that case, if you're going to attack a system and say this system is permanently banned or this system is irredeemable or violates the Constitution, then I don't see how you could have any system that would be unassailable, particularly given the closeness of Arizona.
We've taken you over time,
Elections.
and I know there's another party who wants to.
So I have
Judge Gould has a question.
my question for you is this. If we conclude there's no standing under Article 3, am I correct in thinking that we could not go on in a belt and suspenders type approach to say, alternatively, even absent standing, there's a violation of the 11th Amendment.
I think under Supreme Court case law, that is what is expected.
That we
Judge,
could not make that alternative ruling, absent standing.
I'm sorry.
We could not make an alternative ruling in the absence of standing.
I mean, that is what the Supreme Court case law says.
Okay, thank you.
There's thresholds. Yeah.
May it please the court. My name is Emily Kreger. I'm from the Burgess Law Group, and I'm representing the county appellees in this matter. I don't want to repeat what the state has said. The county joins in the position of the state, but I did want to address a couple of questions that the court provided. As to the question of whether an actual hacking or an actual manipulation is shown, could this relief, could a party come in and request this relief prior to the election? Our position is no. You don't throw out the entire system of tabulating ballots that the Arizona legislature put into place 6 decades ago. The party comes in and gets an injunction to stop the conduct that's at issue, if it's clear evidence that it occurred. And the second piece is that even if this alleged manipulation occurred, there is no evidence there or even a presumption that a harm will result because of it. This is what differentiates this case from Curling v. Kemp, for instance. We have paper ballots in the state of Arizona. That is the ultimate backup should any situation like this occur. And appellant's position that that is not the case and that's not how ballots in races are tabulated in Arizona is incorrect. And the court may take judicial notice of those facts in a 12B1 analysis, either a facial or a factual analysis, and that is what occurred here. And unless the court has any other questions.
I had one question, and it's about, there's a state law that requires that ballots be counted in a certain way, correct? Does it mandate the use of electronic tabulation?
Yes, it does.
It doesn't mandate the choice of particular manufacturers, though.
That is correct.
Who decides which manufacturers' machines are going to be used in a county?
The individual counties make that decision, but it goes through a lengthy process of validation and certification by the Secretary of State.
Yeah, I'm just trying to figure, my interest is trying to figure out who the right defendants are in this case. Does the county recorder make that determination, or does the Board of Supervisors make that determination?
The Board of Supervisors makes the determination as to the vendor that will be used for tabulation equipment.
Okay, so this is a long-winded way of asking the question. The county recorder was being sued in this case. He's no longer the county recorder. And the board is still a set of defendants. But does the county recorder play any role in this at all?
On the tabulation side,
Yes.
the county recorder is not involved in the
That was my
tabulation. They have the recorder has early mail-in ballots, and they're responsible for that. There is some overlap in the county for the transition to that tabulation piece, but overall, it is the County Board of Supervisors in Maricopa County.
That's in charge of selecting the tabulation machinery and it's in charge of selecting the tabulation machinery.
That's correct.
Okay, good.
That's correct.
One question from me is, so do you agree that the plaintiffs have alleged that there was manipulation in the past?
With respect to the state of Arizona?
Yes.
No, I disagree.
Oh, okay. So,
They-
go
They
ahead.
have raised an incident that occurred with Maricopa County's voter registration system, which is entirely separate from the election management system. The election management system, the tabulation system, is an air-gapped system that's not connected to the internet. The voter registration system is a public-facing piece of the voting system in Maricopa County that allows voters to understand if they're registered, whether or not their ballot's been counted, and things of that nature. There was an incident that occurred, but that's entirely separate. And the structures and the safety features that are in place for the election management system are entirely different from that piece.
That's helpful. And then but there was allegations of manipulation in other outside of Arizona then.
Correct. They did bring some outdated allegations about machinery in other states that's not used by the state of Arizona, that don't have the same safeguards in place that the state of Arizona has. They don't have the same certification processes that the state of Arizona has. And it's our position that, simply saying, this fact that there are machines, and Maricopa County uses machines. There was an incident with those machines, therefore there must be an incident with Maricopa County's machines, is not a reasonable inference to make. Okay. I mean, to get to the court's point, their allegation is akin to saying that the Maricopa County Tabulation and Election Center is a building that's built out of concrete and steel, and there are criminals in the world, and there are criminals that break into buildings, therefore Maricopa County can't use buildings in its election process. That is the equivalent of what they alleged in this case.
I think you're right on the merits. My only question is that enough to get them standing?
No, it's not, because it's purely speculative. There is no harm. Mm-hmm. They have not alleged any type of harm, or that there's even the possibility that a ballot isn't going to be counted correctly.
Okay, thank you.
Thank you.
Before you sit down, Judge Gould, did you have any questions for counsel?
Thank you. I have no further questions.
Thank you very much.
I'd excused you prematurely. Put a couple minutes on the clock for Mr. Parker.
In response, and I do want to get to the standing issue as it relates to speculative nature, but this was all argument on the merits, patently. Mm-hmm. And we disagree. This air gap system that separates the voter registration we disagree. And we've got proof, and we will prove it. They think they will prove it. We'll see. That's what litigation is for.
Oh, but the question was whether you had allegations.
We do.
Wait, we do. You don't know and how the question ends before you answer it. Do you have allegations the Maricopa County system or the Pima County system have been manipulated in the past? The voting, she was saying, there may be some allegations that the registration system was manipulated in the past. Are there any allegations in this complaint? I don't see them, that the Maricopa County or Pima County tabulation systems were manipulated in the past.
No, but...
That may or may not be determinative, but I think that's the point she was making.
Well, I think the second point she was making is they're not connected, and one has nothing to do with the other. That is a critical point, because we believe that the registration voting being hacked can, in fact, infiltrate...
But your complaint doesn't allege that. Your complaint is an attack on the tabulation system for voting. It's not an attack on the voter registration system.
No, but it does raise the voter registration in the allegations in the complaint.
Well, all you say is that the system has been hacked in the past. Is there any allegation in the complaint that a hacking of the voter registration system would affect tabulation of votes actually cast?
Well, I think it can be read that way, yes. And in terms of pleading of a complaint, I think absolutely. Paragraph 12 speaks to a whole range of vulnerabilities. One of them is this air gap idea that separates these two.
No, and I'm accepting that there are vulnerabilities for purposes of your argument. You've alleged them. I'm accepting there are vulnerabilities. The question I have is there a separate allegation that somehow the hacking or whatever happened with the voter registration system affects these tabulation machines in some way? And I don't see that allegation anywhere in the complaint.
It is not stated that way. However, when you take the registration voter hacking, along with paragraph 12 talking about the vulnerabilities, it should alarm you to the point where it is a real threat, it is a credible threat, it is more of a threat than existed in Election Integrity Project, which this circuit viewed was sufficient to get over the speculative nature element of the claim. The curling case, which counsel says is completely separate and different, it isn't. We know that paper ballots have to be fed into the optical scanners here, and in curling, ultimately, you take paper over and you put it into the optical scanner. 5.5A is what is used in Georgia. 5.5B was used in Arizona. They are different, but they are substantially similar. And that is an allegation in our complaint that Georgia and Arizona and the issues that existed in curling, while not identical, and while they are different systems, they apply equally, and that is an assertion that should get us standing as well. The speculative nature issue is not just Susan B. Anthony, but it's the fact that curling passed muster, and this complaint is more specific than even that one. The Election Integrity Project speaks to credible threat of harm, and the case that the district court ruled on, Democratic Arizona Party versus Republican Arizona Party, that was the voter intimidation case. There hadn't been any intimidation that had occurred. The election hadn't yet occurred. But in advance of the election, the court determined that the Democratic Party should be able to move forward against the facts that there might be intimidation. And this case really is no different. The key here is if Rule 12 is applied correctly and appropriately, and we argue that the district court did not do that. If it is—
I think you've gone over the additional time. I do have one additional question. I think you can answer it yes or no, but perhaps not. I don't read your complaint as making any statutory claims. Am I correct?
We have a Section 1983 claim.
Right, but that's merely a vehicle. 1983 is a vehicle for making either constitutional or statutory claims.
Yes.
So do you make a claim that any statute was— I don't read in the complaint any claim that a federal statute has been violated.
No, we have a
So
declaratory judgment.
It's just a constitutional claim.
It's a constitutional claim with 1983 and declaratory judgment.
Yeah, 1983 just gives you the ability to come into federal court to make
Correct,
a
Your Honor.
constitutional claim. Okay, thank you.
Thank you, Kel.
Thank you, counsel, all counsel in this case. This case will be submitted, and we will be in recess until tomorrow.